Welcome back to the Constitutional Clarion. This video is another response to viewer questions. First about the history of Western Australia's attempt to secede from Australia and why it didn't work in the 1930s. And secondly about whether or not there's any ability for a state, or indeed people, to secede from Australia today. The Commonwealth Constitution does not contain a provision that permits secession, that is, a state leaving the Federation and becoming independent of Australia. The only reference made to it is in the preamble to the British Act, the Commonwealth of Australia Constitution Act 1900, which also contains our Constitution in Section 9. So that British Act has a preamble and it has sections 1 to 8, which we call the covering clauses, which you'll get a bit of a mention here, along with our Constitution in Section 9. Now, the preamble to that British Act describes the establishment of, quote, one indissoluble federal commonwealth under the Crown, unquote. As I've explained before in other videos, a preamble is not legally binding. It explains the background and the context in which a statute or a constitution was enacted, and sometimes it indicates the purpose to which it was directed. It can be used by a court in seeking to resolve ambiguity in the provisions of that constitution or statute. Hence, an indication in the preamble that the Federation was intended to be indissoluble would likely influence a court in interpreting provisions of the Constitution that deal with things like the formation of states and the alteration of state limits so that they do not accommodate secession. There was also some discussion during the convention debates of the 1890s about whether to permit secession. The American Civil War was still within the living memory of the people who participated in these debates, and because of the horrors of that war, most of them took the view that secession should not be permitted. Western Australia was, from the very beginning, a reluctant participant in federation. When the Commonwealth of Australia Constitution Act was passed by the Westminster Parliament in early July 1900, Western Australia still hadn't agreed to join. Covering Clause 3 provided for Queen Victoria, in issuing the proclamation that would create the Commonwealth of Australia as a federation, to include Western Australia in that proclamation if she was satisfied that the people of Western Australia had agreed to join. This happened after a referendum was passed in Western Australia on the 31st of July 1900, approving Western Australia joining the Commonwealth as an original state. 69.47% of Western Australian voters voted yes, although a lot of that support was actually in the goldfields rather than in Perth and the rural and other regional communities. The economy of Western Australia was also different from the economies of the other Australian colonies. It was almost completely reliant on agriculture and mining. Its tax revenue came from excise and customs duties, which, as a consequence of federation, were transferred to the Commonwealth. It was also affected quite seriously by Commonwealth tariff policies because it had almost no manufacturing base of its own. It therefore needed to import all its equipment for farming and mining, but because the Commonwealth tariffs made otherwise cheap overseas imports very expensive, it was forced to buy this equipment from other Australian states at a slightly cheaper but still very expensive price, which of course reduced its own capacity then to compete in its export of its own commodities. Western Australia was hit particularly hard by the Great Depression in the late 1920s, strengthening an existing secession movement. As it was very unlikely that the Commonwealth Constitution would be amended to permit its secession, the advocates of secession in Western Australia wanted the British Parliament to legislate to take back Western Australia as a Crown colony. Now, this issue was therefore lurking behind the scenes during the negotiation of the Statute of Westminster 1931. This British statute was intended to give legal effect to the earlier political recognition from 1926 and 1930 at the imperial conferences that Britain and the self-governing dominions, such as Australia, were equal in status and that the Crown had become divisible. The Statute of Westminster gave power to the dominions to repeal or amend British laws that had previously bound those dominions by paramount force, meaning that the dominions couldn't legislate to amend or repeal the way those British laws applied to them. The Statute of Westminster also said in section 4 that the Westminster Parliament could not legislate for a dominion as part of its law unless it was declared in that legislation that the dominion had requested and consented to its enactment. The problem for Australia as a federation was that the Commonwealth Constitution was legally entrenched in Australia precisely because it was part of a law that applied by paramount force. If the Statute of Westminster allowed the Commonwealth Parliament to amend or repeal any British laws that applied by paramount force, including the Commonwealth of Australia Constitution Act, then that would have undone the entrenchment of the Constitution and potentially destroyed the Federation. So special savings provisions were included in sections 8 and 9 of the Statute of Westminster to preserve the Commonwealth Constitution and the Commonwealth of Australia Constitution Act in which it sits. The states also managed to get the British to insert section 9 subsection 2 into the Statute of Westminster. It said that Commonwealth consent was not necessary for the enactment of British legislation with respect to any matter within the authority of the states of Australia, not being a matter within the authority of the Commonwealth Parliament or government, but as long as it would have been in accordance with prior constitutional practice for the Westminster Parliament to make that law without Commonwealth concurrence. Now, Western Australia did that because it thought that this would allow it to get the British Parliament to pass a law concerning its secession from Australia without the need to get Commonwealth agreement. However, it would have to establish that A, it was a matter solely within state authority, not Commonwealth authority, and B, that before the enactment of the Statute of Westminster, it would be consistent with constitutional practice for the Westminster Parliament to make such a law without Commonwealth agreement. Now, not long after the Statute of Westminster was enacted, the secessionist movement really took off in Western Australia. The nationalist government of James Mitchell began to support it and got the Secession Referendum Act 1932 passed through the Parliament of Western Australia in December of that year to provide for the holding of a referendum on the issue. Now, technically today we would call this a plebiscite, not a referendum, because it didn't itself amend the state constitution or even the Commonwealth Constitution, but nonetheless, because they call it a referendum, I will too for the purposes of this video. The Labor Party bitterly opposed secession, so the idea of secession did become a highly partisan issue. The referendum was held on the 7th of April 1933, on the same day as the state election. The people were asked this, quote, "Are you in favour of the state of Western Australia withdrawing from the federal Commonwealth established under the Commonwealth of Australia Constitution Act, Imperial, ? Unquote. They were also asked whether they wanted a convention to be summoned to propose alterations to the Commonwealth Constitution. While the second question on a constitutional convention was defeated, the question on secession was successful, with 138,653 voting in favour and only 70,706 voting against. So about 2/3 of the people who voted were in favour of secession. Curiously, on the same day, however, Mitchell and his nationalists who had supported secession were defeated and the Labor Party was elected to government. So this left the new Labor Premier, Philip Collier, in a rather peculiar position because he was then responsible for giving effect to a secession referendum which he and his government did not support. Collier decided that he had to give effect to the wishes of the people, so the Secession Act 1934 was passed, approving the publication of a case for secession, which was a document prepared by a committee of the Parliament. It also authorised a delegation to petition the Westminster Parliament to enact a law that amended the Commonwealth of Australia Constitution Act to give effect to the withdrawal of Western Australia from the Federal Commonwealth of Australia. It would establish Western Australia as a distinct self-governing colony of the British Empire to be called the Dominion of Western Australia and give it the same constitutional status as the Commonwealth of Australia. You can read the full details of the petition because it's a schedule to the Secession Act 1934, which you can find on any database that lists Western Australian legislation. It also set out all of Western Australia's grievances and its reasons for wanting secession. The Commonwealth Government responded by publishing the very detailed reply named The Case for Union. Now, I did manage to pick up a copy of this once from a second-hand bookshop, so very pleased with that acquisition. It set out not only the political arguments, but also the evidence refuting many of the economic arguments. As is commonly the case with claims being made from secession or withdrawal from a group, like Brexit, for example, normally only the perceived advantages and benefits are counted by its proponents. The Commonwealth case pointed to the added costs and losses, concluding that Western Australia would have to raise taxation significantly as a result of secession. It observed, quote, "This completely dissipates the mythical benefit of £2,332,000 put forward in the Western Australian case. It is not a question of estimating what Western Australia would gain financially by secession. It's a question of placing a reliable figure on what Western Australia must inevitably lose," unquote. But in the end, the secession question didn't come down to its merits. It was a matter of law. The Westminster Parliament established a joint select committee on the 23rd of February 1935 to consider whether a petition from Western Australia ought to be received. It heard evidence from counsel from both Western Australia and the Commonwealth. Section 10 of the Statute of Westminster 1931 said that sections 2, 3, 4, 5 and 6 shall not apply to Australia unless adopted by Australia. And at that stage, in 1935, Australia had not adopted the Statute of Westminster. It did so later in 1942 with retrospective effect back to the beginning of the war. Section 9 of the Statute of Westminster, however, did apply. But the Dominion's Office and the British Crown Law Officers thought it was irrelevant because Section 9.2, which you might remember is the one the Western Australians thought was the key to give them secession, they said, well, wait a minute, Section 9.2 concerns exclusively state matters where there's no existing constitutional practice to gain the concurrence of the Commonwealth before the British would legislate. Even without the application of Section 4 of the Statute of Westminster, which is the one that reaffirmed that the British Parliament would not pass laws extending to a dominion without its request and consent, such a constitutional practice already existed and was mentioned in the preamble to the Statute of Westminster. Hence, while technically the Westminster Parliament could legally legislate for Western Australia's secession, it was not consistent with constitutional practice for the Westminster Parliament to do so without the concurrence of the Commonwealth Government and Parliament. The UK Joint Select Committee noted that there was no power in the Commonwealth Constitution for a state to secede. The Constitution could be amended by a referendum, but the committee considered that a referendum permitting secession would conflict with the covering clauses in the Commonwealth of Australia Constitution Act, which themselves could not be changed by Australia at that time. The committee concluded that only British legislation could provide for, quote, the dissolution of the Commonwealth or the secession of any of its constituent parts, unquote. The committee considered whether secession was a matter concerning Western Australia alone or whether it was also a Commonwealth matter. As Western Australia's request for secession would have involved changes to the Commonwealth Constitution, the committee concluded that the request of the Commonwealth Parliament and Government was required. It decided that the petition could not properly be received, as it would not be proper for the United Kingdom Parliament to act without the request of the Commonwealth of Australia conveying the clearly expressed wish of the Australian people as a whole. In the face of this rejection, Western Australia gave up its quest, as the Commonwealth would not agree and the United Kingdom Parliament would not help. There was the odd suggestion of rebellion and civil war, but they were quickly quashed by wiser heads. Now, for those of you wanting to know more about it, there's a very good book on it by Greg Craven, which he wrote some time ago. You might be able to pick it up now in a second-hand bookstore or perhaps in a library, but it's probably out of print by now. Okay, so what about today? Could a state secede from Australia today? Now, the British method for achieving secession has now gone with the enactment of Section 1 of the Australia Acts 1986. It provides that laws of the Westminster Parliament can no longer be made to extend as part of the law of Australia. So no change that the Westminster Parliament made to the Commonwealth Constitution would have any legal application in Australia today. The Commonwealth Constitution still provides no procedure for secession. While Section 123 provides a method for changing the limits of a state, that is its borders, this does not provide for the exclusion of any part of that state from the Commonwealth. If that part were within an original state, and all the existing states were original states, then it would retain its constitutional status as part of Australia, including the right to representation in the Commonwealth Parliament, unless the Constitution was amended. Can the Constitution be amended to provide for secession? What about that clash with the covering clauses and the word indissoluble in the preamble? Well, the preamble, as I said earlier, does not have a legally binding effect, but it does have an interpretive value. The covering clauses, including the definition of original states and states, can now be amended or repealed through the use of Section 15 of the Australia Acts, altering their protection by the Statute of Westminster. So yes, there is a means through the combination of a referendum and cooperative state and federal legislation amending the covering clauses that could legally achieve secession. Any referendum would require the approval of a majority of voters overall, a majority of voters in a majority of states, as well as a majority of voters in the seceding state due to the operation of the penultimate paragraph of Section 128 of the Constitution. And as you can imagine, the chances of achieving this are infinitely small. Unilateral secession by a state would not be legally valid. Any legislation enacted by a state to provide for its secession would be invalid because of its inconsistency with the Commonwealth Constitution. But unilateral secession could in practice be effective to the extent that Australia chose not to engage in a civil war, not to send in the tanks. It would be, in effect, a matter of politics. What about those people who claim that they've seceded from Australia? You know, the ones, they tend to wear purple robes and call themselves prince and princess. Have they actually validly, legally seceded? Well, the answer is no. Sometimes it's humoured to the extent that the authorities can't be bothered wasting time and money on them, but often the law is enforced against them. For example, in the 1999 case of Fife and Victoria, Mr Fyfe's argument that he'd seceded from the state of Victoria was rejected as an abuse of process. The Court of Appeal pointed out that Mr Fyfe resides within the boundaries of Victoria and he's therefore subject to the laws of Victoria, just like everybody else who's there. In Harrison Muirhead in 1993, a Queensland judge rejected a claim of secession as a cynical assertion made to avoid financial obligations. The judge criticised the Muirheads for putting themselves above the law, and he regarded their actions as an insult to ordinary Australian citizens who have considerable difficulty in paying their debts but still obey the law. Even the most famous of Australia's pseudo-secessionists, Leonard Casley, who called himself Prince Leonard of Hutt, did not have their claims to secession accepted by the courts. These claims were described by a High Court judge in 2007 as, quote, fatuous, frivolous and vexatious, unquote. A Western Australian Supreme Court judge concluded in 2017 that Casley's claim to be sovereign of Hutt River Province and that Western Australian courts had no jurisdiction over him had no legal merit or substance. The judge said, anyone can declare themselves a sovereign in their own home, but they cannot ignore the laws of Australia and not pay tax. In the end, the claim to sovereignty was dropped in 2020 and the land, what was previously known as the Hutt River Province, had to be sold to pay back the tax debt that was owed. There are plenty of other cases in the courts where claims to secession have been rejected and the laws of the Commonwealth and the states have been enforced. Thank you for watching the Constitutional Clarion. I hope that this helped you understand the rather tricky and sensitive issue of secession a little bit better. And as always, I look forward to seeing you next time. Goodbye.